So, good morning and welcome to the second webinar in our three-part series exploring the challenges facing the construction industry. In the first webinar, we discussed insolvency in the industry. In this webinar, we will consider payment and contract administration. Our series will then conclude with our third webinar on the 9th of December on omitting works under a contract and termination. All three webinars in the series will be recorded and available on the Shepherd and Wedderburn YouTube channel if you would like to listen again or catch up. Before we begin, there are a few of our usual housekeeping matters to start with. To minimise background noise, I've placed you all on mute. And if you would like to ask a question, please do so using the webinar Q&A function. And we'll try to address as many of those as we can at the end. In order to keep within the 30 minutes, though, we will answer those at the end of the presentation rather than as we go along. So I am Nathaniel Buckingham, a partner in the Property and Infrastructure Disputes team at Shepherd and Wedderburn, specialising in construction and engineering disputes. My background is in engineering as a chartered civil engineer for 7 years before moving into the law. My current practice is varied across the construction industry, but I have a particular experience with major projects, private finance, and the industrial and energy sectors. I am joined by my colleague Kirsty Gray, a senior solicitor in our Property and Infrastructure Disputes team. Kirsty's work focuses on construction disputes across numerous sectors, and she is experienced in traditional litigation, alternative dispute resolution, and dispute avoidance across the UK. Now, as construction dispute specialists, we have both a strong understanding of the legal aspects, but also the commercial background to the disputes that we encounter. We have substantial experience in advising on all standard form construction contracts and the payment provisions within them. And our team is recognised as market leading with broad and in-depth experience. Now, it's this experience which forms the basis of the advice that we give to clients and the information that we will be sharing with you today. Please do feel free to contact either of us using the contact details on screen to discuss any matter raised in today's webinar or more widely. So I will now pass over to Kirsty, who will run through the agenda for today's webinar.
Thank you, Nathaniel. So for the agenda, the session today will begin first with a discussion on the common pitfalls that we see with contract administration and on managing payment provisions. We'll then move on to consider best practice in relation to contract administration that would mitigate the risk of these common pitfalls. Then, as the industry has seen an increase in smash and grab adjudications, we will turn our focus onto how to minimise the likelihood of these coming up. Compensation events under NEC contracts and relevant matters under JCT contracts will be discussed before we move on to contract administration in the case of delay. Our webinar will then finish with a question and answer section, and you can put your questions in the Q&A box as we go along. So to start off with our common pitfalls around payment and contract administration, as we discussed in our first webinar, the construction industry is facing a lot of unforeseeable and challenging risks at the moment. However, one of the most common risks, the poor administration of contracts, can be easily foreseen and mitigated. So in 2023, King's College London published a report that covered trends on the construction industry. And in that report, it confirmed that inadequate contract administration was responsible for 42% of all disputes that were referred to adjudication in that year. So this statistic suggests that nearly half of all adjudications in a single year were caused by a risk that could have been addressed by proper training and adequate processes. We've also seen an increase in the number of smash and grab adjudications that also arise from the failure to serve a payment or a pay less notice on time. We'll establish and expand on this later in the session. So the common pitfalls that we're going to cover in relation to contract administration are A lack of understanding of the underlying contract documents by the project team, B, the absence of effective processes and poor organisation, and C, a failure to identify and monitor ongoing risks. These factors contribute to the increase of disputes in relation to contract administration, but there are some ways that this risk can be managed and mitigated. So taking a look at those three pitfalls that we identified, the first one is understanding the contract. So ensuring that the project team and those involved in contract administration understand the contract and associated documents is the most effective way to minimise risk in this area. So having a knowledge of the provisions, processes and risk allocation of the contract should allow the appropriate actions to be taken at the correct stage to ensure that the project is smoothly run. Ensuring that this knowledge is present throughout the project personnel is important, especially in relation to complying with formalities in the contract, such as notice periods. Also, having an understanding of the key construction legislation and regulation that is relevant to the project and that underlies the contract is important. The legislation operates in conjunction with construction contracts, and it will have requirements that are separate to the text of the contract itself. So, for example, those involved in payment applications should have an awareness of the requirements under the Housing Grants Construction and Regeneration Act, which is known as the Construction Act, as this governs formalities around payment and pay less notices. Turning on to item B on that list, on effective processes and organisation, having reliable processes in place and keeping detailed records of the progression of the project is crucial in terms of minimising risk. For record keeping, detailed accounts should be kept in all areas, but particular care should be taken to record the details of matters that have been identified as potentially contentious. Having that evidence on hand becomes really beneficial later if the wider organisation or external consultants are engaged in the event of a dispute down the line. In particular, records of any key discussions should be kept. It can be difficult to prove a conversation took place if there's nothing in writing to record it. So to avoid that he said, she said scenario down the line, we always would recommend that written records of discussions are kept, which can even be a short file note or a follow-up email to the person who's being spoken to with areas of agreement identified. So identifying those risk areas and processes to mitigate those risks at the outset of a project makes it far easier to keep those detailed records as personnel are aware of what the warning signs are and the information that they should be trying to gather at all stages. So item C on this list was the failure to identify and monitor risk. So identifying risks at the early stage is crucial to allow the appropriate mitigation measures to be put in place and to ensure that the contract is complied with throughout the project. We often see risks are identified by members of the team, but they're not escalated up to the adequate level, which can be an issue in ensuring that the contract is complied with. So some measures that could be implemented to decrease this risk would include having appropriate recording and reporting processes in place, ensuring that updates are regularly shared through personnel and through team meetings, and ensuring that the relevant personnel at each level of the project have adequate training on how to comply with the letter of the contract. So these examples of best practice that I've just discussed focus on general contract administration. I'll pass you back to Nathaniel now, who will discuss smash and grab adjudications and how we can avoid them.
Thanks, Kirsty. So as most of you will be aware, smash and grab adjudications are a significant risk in the construction industry. Now, figures on construction adjudication produced by King's College London in 2024 suggest that each year smash and grab adjudications account for around 63% of all adjudications. The prevalence of poor contract administration, particularly around payment, contributes to how common smash and grab adjudications have become. Now, for those of you who don't know, or as a reminder for many of you, smash and grab adjudications are where a payment process has not been followed properly and the contractor is due the sum of money they asked for in their payment application, potentially inflated, and the adjudication would just be about the payment technicality of that sum being due, not whether that is the true value of work done and the sums due to the contractor. And it arises when a payment notice and pay less notice is not issued by the employer side. Now, the risk of a smash and grab adjudication can be minimised and even avoided by good contract management and simply ensuring that valid payment notices and pay less notices are given in time. Examples of best practice that we know about to help with this include ensuring those administering the payment aspects of a contract are properly trained on the contractual provisions and timescales, and that the specific provisions and timescales of each contract have been reviewed and looked at because they might have been amended from the standard form. We also recommend keeping detailed records of notices, as it makes it much easier if a defence is needed to be made regarding a payment application being invalid or inflated. On a much more simpler note, the effective management of email inboxes is an easy win in this regard. Inboxes that might receive payment applications should be monitored for such applications, and you should check that the email has actually sent if issuing a pay less notice. And finally, responding to notices, even if you're not sure whether something from the contractor is an application or not, it is much better to have something in place against an invalid payment application than to have not responded when it turns out that is a valid payment application. So those are a few of the recommendations of how to minimize and avoid smash and grab adjudications. Now, I'm now going to consider the key failures in relation to the administration of payments. It's not unusual in the construction industry for projects to be delayed due to unexpected changes or unforeseen events. The industry standard construction contracts reflect this reality and allow for a contractor to be given more time to complete and reimbursed for any additional costs and expenses that are incurred in the event of a delay that is not the contractor's risk. Now, each standard form contract deals with these events slightly differently, and today we'll be considering the NEC and JCT contracts. As many of you will know, the NEC suite of contracts deal with delay through compensation events, whereas JCT covers these delays through relevant events and relevant matters. So compensation events under NEC contracts are events that can impact the cost of completing the works or the time it will take for the works to be completed. They are a mechanism that allow a contractor additional time to complete the works and therefore relief from liquidated damages that may otherwise be due, or provide the contractor with additional payment due to an unexpected change or unforeseen event. These provisions are an important way to manage the risk of a project being delayed or running over budget while maintaining fairness and efficiency. Looking at some examples, Clause 60.1 of NEC contracts provides for 21 compensation events, and they can broadly be categorized in three ways. The first is where the client, the project manager or supervisor, fails to take an action that's required of them to take under the contract. The second is an instruction or other change by the project manager or supervisor provided for in the contract. Now, a key example of this type of compensation event is when an instruction is given by the project manager to change the scope. And the third of the compensation event groups is a supervening event that occurs and where the contract has allocated the risk for this event to the client. Now, the NEC contracts also allow for bespoke compensation events to be detailed in the contract data, and this allows parties to cover a scenario that is not neatly tied off under the definitions in Clause 60.1. So again, a recommendation is always to look at your contract and see exactly what compensation events are in play and where the risk allocation lies for those. And it's important to note that compensation events do not trigger automatically. Both project managers and contractors are entitled to notify compensation events under the contract. However, there are strict timescales for notification, assessment, and quotation, which must be adhered to in relation to particularly in relation to the notification of compensation events. So on this notification procedure, it is essential that compensation events are notified to the project manager within 8 weeks of the event occurring. Otherwise, the contractor is not entitled to an extension of time or an increase in price at all. They will have lost the ability to make that claim in relation to the compensation event. Now, the rationale under NEC for these strict timescales is to encourage the parties to continually collaborate throughout the project and deal with issues as they arise, rather than delaying events building up over the duration of a project and being quite difficult to then deal with at the end. I would recommend that you check your contracts to look at this notification procedure in case that period has been amended. It's not unusual for there to be an even shorter period in which the contractor has to notify of a compensation event. I'll now hand back to Kirsty, who will consider the equivalent provisions under the JCT contract.
Thank you, Nathaniel. So the JCT suite of contracts have a similar mechanism for dealing with events that may affect the progression of works. These are labelled as relevant matters. And relevant matters are issues that either the employer is responsible for or issues which the employer bears the risk for contractually. Relevant matters must have the potential to affect the progress of the work and may entitle the contractor to claim loss or expense. So some examples of relevant matters would include variations to the contract that are instructed by the employer, a legitimate suspension by the contractor, and instructions given by the contract administrator. Relevant matters are not to be confused with relevant events. Relevant events allow the contractor to claim an extension of time. However, relevant matters only allow a claim for additional money, and these are covered by clause 421 of the standard JCT contract. The rationale behind relevant matters in the contract is that if the works are delayed, the contractor would incur cost and expense associated with the operation on site for a longer period of time than initially expected. The provision here allows for additional expense to be recovered where an event is correctly defined as a relevant matter. In order to claim under the relevant matter provision, the following procedure must be complied with. So first, the contractor must make an application as soon as it becomes apparent that the progression of the project is likely to be impacted by the relevant matter. And if requested, the contractor is obliged to submit the reasonably necessary information to the contract administrator or quantity surveyor to assess and ascertain the loss in value that has been incurred. The assessment must be updated by the contractor on a monthly basis to comply with clause 4.20.3 of the standard contract. It is considered best practice for the contractor to keep records and to circulate information that would enable the contract administrator to take a view as to, firstly, whether the progress of the project has actually been affected by the relevant matter, and if so, how that relevant matter is connected to or may lead to the loss that is being claimed for by the contractor. So the loss and expense incurred by any relevant matters that have been claimed under the contract are to be included as an interim payment. Therefore, because the payments are being made semi-regularly through interim payments, it's important that relevant matters are applied for and are assessed by both parties promptly. Moving on to the question of administration of contracts around delay. From our experience, disputes often arise here where projects are delayed, as the parties may not administer contracts, especially payment provisions, strictly in accordance with the letter of the contract or best practice. Delays often trigger the requirement for a notification to be given under the contract. The contract will have strict notification requirements, and it is essential that those are complied with and the process is managed efficiently to ensure that compliance is made. So where a delay occurs in a project, it is important to consider the impact that this will have on the programme. From the outset of the project, the contractor will produce a programme that complies with the completion date under the contract. That programme is a key factor in the management of the project and its completion, but it also allocates and assesses the costs and potential risks that may lead to dispute. Some best practice for managing the programme throughout a project would include having in place procedures that allow for the programme to be regularly reviewed and updated, reporting changes, especially delays, to relevant parties and to stakeholders, and consistently monitoring the programme in relation to the progression of the project. Where the contractor has not kept the programme up to date, despite programme dates changing throughout the time of the project, the employer should request that the contractor provides an updated programme. Often, the employer is not proactive in chasing an updated programme, as the responsibility to update it and to notify the employer of delay would fall within the contractor's responsibility. However, working to an outdated programme can also lead to disputes down the line where there's disagreement over dates. The programme should therefore not be forgotten about and should be treated as a living document that's updated in the event of delays or change as they come about. That will reduce the risk of disputes down the line. It would help to manage delays and assist parties in understanding how to comply with their obligations under the contract.
Thank you, Kirsty. So we've reached the end of our presentation today, and we've got plenty of time left for to answer any questions. So we'll just have a look and see if there are any. If you've not already done so, please do type your questions into the Q&A function on the webinar on the webinar screen. So there is a question in. So the question is, you've mentioned interim payments during the webinar. Please, can you expand on when interim payments are available? Kirsty, I wonder if you could answer that for us, please. Talk about interim payments.
Thanks, Nathaniel. Yeah, so for interim payments, essentially where we have works under the construction contract and are going to take longer than 45 days to complete, that's when you can apply for an interim payment. So it's really at the discretion of the contracting parties to decide the value of those payments, the dates that they become payable. Saying that, the only caveat is that under the Construction Act, the underlying contract would have to have an adequate mechanism for determining the value of those interim payments. So, and if the contract is silent on that point, the default provisions in the construction contract scheme, so scheme for construction contracts, kicks in. So under the scheme, I think the default position would be that periodic payments are calculated with reference to the value of the work that is being performed. Then also must refer to the relevant period that is designed in the contract. And if that period isn't stated in the contract and it can't be calculated by reference to the words in the contract, the scheme provides a default period for 28 days. So once an application is made, that obligation to make an interim payment is triggered. And then the due date that we're looking at here is the later date of either the application by the contractor or 7 days after the relevant period expires. So there's the default provisions in the scheme for construction contracts, but if the contract does set out an adequate mechanism for determining payments, then the contractual provisions will apply instead.
Thank you, Kirsty. So we've got another question, which is, what is the position in relation to the issuing of payment notices? And we touched on payment notices in relation to the smash and grab adjudications. And a payment notice is if a contractor issues an application under a contract, the payment notice is then the notice that sets out what is actually due. And as I mentioned earlier, it's the main way of avoiding a smash and grab adjudication is to make sure there's a valid payment notice in place. Now, under the Construction Act, payment notices must be issued 5 days after the payment due date. The notice can be issued by either the payer, which is most normal, or the payee. There are contracts that provide for the payee to issue the notice, or the specified person in the contract. So it's important to check the contract that you're working under to know who is to issue the payment notice and when, in case it's any different to the Construction Act requirements. The payment notice must specify the sum considered to be due at the payment due date and the basis on which that sum is calculated. And it's important, really, on a contract administration basis, to always, if the contract has regular interim payments, for example, to always issue payment notices, even if no sum is due. And to set out the basis upon what any sum due is. And if anything's missing, if any of those components are missing, then that's where you run the risk that a contractor will say the payment notice is invalid, and the contractor's payment application takes precedents and can then lead to a smash and grab situation. So making sure that the payment notice contains what it has to contain, the sum due and the basis upon which it's calculated, making sure that it's issued in time in accordance with the contract and issued to the correct people, then that will be set out in the contract as well. That's the best way to avoid smash and grabs, as I mentioned earlier. Now, if a construction contract is not Construction Act compliant and doesn't have those provisions in relation to payment notice provisions, that is, then the terms of the scheme for construction contracts are implied automatically. Now, those provisions require the paying party to give a payment notice no later than 5 days after the due date for payment. So that's worth that's worth knowing whether you have an adequate mechanism in your contract or are operating under the scheme. We've got another question here. In your experience, what factors are relevant if faced with late payment scenarios? Kirsty, I'll let you answer that one, please.
Well, thanks, Nathaniel. So we've discussed a few of the factors, which would be obviously risk of smash and grab adjudication and so on. But another key consideration would be the accrual of interest of the sum due. So there's a few ways that might happen. So under statute, the Late Payment of Commercial Debts Act, there is a statutory right to claim interest on late payments in commercial contracts. So that applies to what are termed as qualifying debts, which are debts that relate to the payment of the contract price in a construction contract. So that rate at the moment is 8% above the Bank of England base rate. That's quite high. As the base rate is 4% currently, interest would accrue at a rate of 12% here. And then if there is a contract that tries to exclude that statutory right to claim interest, that won't apply, that will be void unless the contract has an alternative substantial remedy for late payments. So we'll often see contractual interest within a contract that will sort of serve instead of this. So, and that, to sort of just determine whether that's a substantial remedy, we need to think about, is this remedy sufficient to compensate the supplier or to deter a late payment? Would it be fair and reasonable to provide that remedy as an alternative? So that accrual of interest, it applies in most cases and it's something to be aware of. It can, in some cases, be disapplied if the contract does provide for it. And that's particularly around cases where there's a dispute around the value of or the need to make a certain payment. So the point of the legislation, I guess, is really to say that the intention is to penalise those who have no good reason for a late payment, but the interest provisions in the contract have to be fair. So if there is a dispute going on, and bargaining position of the parties maybe being a bit uneven, for example, those are potential scenarios where interest may not accrue at that point, but it is a point that is particularly relevant where there is a late payment scenario, particularly given the value of the statutory interest at the moment.
So there's another question here. What is the difference between the payment notice and pay less notice? That's a good question. So in a normal contract situation, a contractor will issue a payment application asking for the money that they think they are due. The payment notice is the most important notice. That is usually given by, for example, the project manager or contract administrator under JCT and NEC contracts. And that's the project manager or contract administrator is then assessing that application, assessing the work that's been done, and issuing a notice that says, as I mentioned earlier, this is a sum that's due at the due date. And it can be given by other people, so just be aware of that and look in the contract. But the payment notice is the one that sets out what the administrator of the contract thinks is due. That the sum that's in the payment notice is what is to be paid by the final dates for payment by the employer or client, unless the employer or client disagrees with that sum. And if they disagree with it, and they might do, because the payment notice might be given by a separate professional, by the contract administrator, project manager, they might disagree with that sum. And the employer or client is then entitled and able to issue a pay less notice saying, I actually am going to pay less than I've been told to pay in the payment notice. And provided they issue that pay less notice, they are then allowed to pay what they think is due. So there's almost sort of three bites there. The pay less notice provisions are kind of similar to the payment notice. It's got to set out the amount that the client or employer in that case thinks is due, but it's actually at the date of the pay less notice itself, and it's also got to set out the basis. So you can't simply say that you're paying less. You've got to explain why, so the contractor knows what they're arguing against. And provided that's all in place, it becomes a valid pay less notice, and the employer would only pay the amount that they've said in that pay less notice. Often payment notices and pay less notices are done together with a project manager and contract administrator and client all being aware of the steps that are about to be taken. So that's the difference between those two. And I know we're slightly over time, but I've got one last question I'm going to answer. If a client elects to deduct liquidated damages, if the contractor has not achieved practical completion, is this done via a pay less notice? And that's a relatively simple answer. It can be taken, the liquidated damages can be deducted in either the payment notice if the project manager or contract administrator decides to do that, or if it's not done in the payment notice, it can be taken out in the pay less notice. So again, that's where usually there'll be a little bit of discussion between project manager, contract administrator, and employer client, making sure that the liquidated damages are taken out somewhere. Otherwise, you'll lose your ability to take them in that interim payment cycle. So thank you for all your questions. We've actually managed to get through them all, which is great. But if you've got any other questions, as we said earlier, please do just get in touch with us, and we will be happy to speak with you and answer them afterwards. This webinar has been recorded and will be available on YouTube. So if you know of any colleagues who haven't been able to participate today, or if you think it'd be useful for anyone, then please just let them know, and we'll circulate details of the recording to the participants after the webinar. And the final thing is we've got one final webinar taking place on the 9th of December. And as I mentioned at the beginning, that's going to focus on the omission of works, de-scoping, and the related termination provisions. If you wish to sign up, you can do so by visiting the news and events section of our website. So I'd just like to thank you all very much for attending today. We hope to see you at the next webinar in the series. And if you'd like to provide feedback on this webinar, including suggestions for topics for future webinars, there will be a feedback survey coming out once the series has concluded. So we look forward to welcoming you back on the 9th of December. Thank you.